Every year, 34 million people are injured or killed as a result of product-related accidents. Such injuries are the major cause of death for people between the ages of 1 and 36, outnumbering deaths from cancer or heart disease. The estimated cost of these injuries is $12 billion annually. As Americans, we buy and use millions of products every day at home, work, and on the go, from electronic equipment to home appliances and tools. We trust these products to make our lives better. It may not occur to us that faulty and defective products could injure us or even kill us. The bottom line is that manufacturers are required to make products safe. The majority of consumers may think they are fully protected from dangerous products by benevolent corporations that will go out of their way to prevent injuring or killing their customers. Or they may think that they are adequately protected by government regulations designed to keep unsafe products off the market. Unfortunately, that is not always the case. A good case in point is a product we all take for granted today, the automatic garage door opener. Once a luxury, the garage door opener has become a true necessity, operating in more than 35 million households across the country. A garage door is oftentimes the largest and heaviest mechanical device in one's home, with an average weight of more than 400 pounds. Each year, more than 30,000 people are injured by automatic garage doors, a large number of them small children. Garage door accidents are often catastrophic, resulting in broken bones, severe head and brain injuries, and spinal cord injuries, and sadly, even death. Many garage door accidents occur as a result of a garage door manufacturer defect or a defective garage door protection system. In an attempt to save lives and reduce the number of adults and children who suffer catastrophic and other debilitating garage door injuries, the Consumer Product Safety Commission has required all automatic garage door systems manufactured in and after 1993 to have a built-in safety, reversing, or automatic shut-off system. The safety and accident avoidance system is designed to automatically stop and reverse the garage door when an object enters the door's path on its way to the ground.
The garage door is the largest movable item in your house, but there's various safety features built right into it.
Okay.
For example, if you notice down here at the bottom, there's electric sensors, and there's one on each end.
Right.
And if anything breaks that beam while the door is closing, then the door automatically stops and reverses and goes back up.
Oh, okay.
So you can simply put your foot in the way, and you saw that it stopped and reversed. Additionally, there's a contact sensor, which means if it comes down and makes contact with anything in its way, it'll stop, reverse, and go back up.
Okay, so that's in the bottom of the garage door.
Well, it's actually a sensitivity setting on the unit itself.
Okay.
And when it makes contact, it stops, reverses, and goes back up.
Okay.
Now, the Consumer Product Safety Commission recommends that you check this by putting a 2x4 or 2x8, this happens to be a 2x10,
Okay.
in the pathway, and then closing the garage door. And what should happen, when it makes contact with that board, it should stop and reverse.
Okay.
Okay? So let's take a look.
While these systems include photoelectric sensors mounted on the garage door jambs and pressure-sensitive sensors inserted on the bottom of the garage door, the Consumer Product Safety Commission found that 40% of them failed to work properly, and the garage doors that failed to reverse came down with enough pressure to crush a small child. More than 30,000 people a year are injured in garages and garage door-related accidents. Today, the Insider Exclusive goes behind the headlines in Consumer Safety Win, Defective Garage Doors, to examine how Victor Pribanic, founding member, Pribanic Pribanic, won a landmark court decision for his client, Ashley McAuley, in a difficult and challenging products liability case which resulted in new consumer protection legislation. Prior to 1992, cases like this had been tried and successfully won by these same manufacturers. In order to win this case, it was necessary to find additional evidence, and Victor's firm found it in the most unlikely of places. A good Samaritan, a retired employee of the manufacturer, a whistleblower who did the right thing. provided extremely valuable information about the way in which the garage door was unsafely designed. Because of that critical inside information, Victor was able to successfully settle this case against the manufacturer of the garage doors for failing to install an electronic eye safety beam, which at that time was then offered at an additional cost of only $50, and for defectively designing the contact reverse system, which should have caused the garage door in this case to reverse direction if it had contacted anything prior to the floor and would have prevented serious injuries. The case was settled at mediation for a confidential sum. But most importantly, this case has resulted in important legislation. In 1992, a law was passed requiring the infrared system as a mandatory safety feature in all garage doors because of the number of deaths and injuries sustained by mostly children trapped beneath them prior to 1992. From autos to appliances to toys and tampons, civil lawsuits actually do save lives by holding manufacturers accountable for dangerous defects ignored in the name of profits. Victor Pribanic has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in White Oak, in Pennsylvania, and in the United States. His goals, not only to get justice for his clients, but to make sure products are made safer and manufacturers more accountable. These successes drive him to help more people who have been harmed by corporations who put profits ahead of people. Victor has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from White Oak, Pennsylvania. It is my great pleasure to introduce Victor Pribanic to the show. Welcome to the show, Victor.
Thank you, Steve.
Tell our audience a little bit about your firm, what kind of law your firm practices.
We represent people who have been injured in some way or some shape or form by medical institutions, corporate America, even their neighbors in some cases.
You are an excellent lawyer. You could work for corporate America, but you choose not to. You represent the little guy. Why?
They need it. It's spiritually, emotionally rewarding. We make a living at doing it. It's they're good. And it feels like the right thing for me to do. I started out learning to be a trial lawyer, the ill thought of trial lawyer today as a prosecutor, prosecuting criminals in the district attorney's office, and went on from there to represent people who are harmed by other things, entities, and individuals.
When you win a hard-fought case and you get a really good verdict and your client looks at you with the tears in the eyes and says, "Thank you, Victor," how does that make you feel?
That makes you feel wonderful. It really does. It's a wonderful feeling, fleeting feeling. It goes away fast, but wonderful feeling, and it's mostly a huge, huge relief when the right thing happens in a trial.
Today we're here because you had a landmark case against a garage door manufacturer. It happened a number of years ago. Right. Would you tell our audience a little bit about what happened to little Ashley McAuley?
Ashley was home with her mom and her older brother in their home in suburban Pittsburgh, Pennsylvania, and her mom was taking a nap, as any mom has a right to, and little Ashley got into the basement and played somehow with or touched the button for their automatic garage door and somehow became trapped beneath the garage door, which failed to go up, and as things would have it, Ashley was trapped with her neck pinned underneath the garage door, and when found, was alive but asphyxiated and suffered severe brain damage as a result of this incident.
In researching this show, I found out that the garage door in a house is probably the biggest appliance that any homeowner has in their house, not really realizing it. They weigh typically, I think, about 400 pounds.
Right.
And coming down on a small child, you know, this could cause serious injuries.
Right.
The case was what, 1992?
Correct.
As a result of the case, what happened? What new legislation was passed?
Well, legislation was passed at around that time requiring garage door manufacturers to have the infrared sensors that would require the garage door to go up. They had already been required to have sensing devices, so this kind of thing could not happen where a child could be pinned or an adult could be pinned under the garage door and asphyxiated, but it failed to function adequately in this case, obviously.
What were some of the legal issues that you had to prove in this case?
Products liability cases in general are technically difficult. They can be costly to pursue. We have to demonstrate in a product case that the thing, whatever it is, garage door opener, car, plane, whatever, are unreasonably dangerous. That often, almost always, requires technical proof, and you have to be able to show to a jury of 12 of our fellow citizens, 12 of our neighbors, why this thing that was put out there is in and of itself unreasonably dangerous. A product liability trial is a trial of, if you will, under the strict liability laws, it's called, of the product. The product goes on trial.
Did it help or hurt in the respect that the garage door manufacturers offered this option of a sensor control, but they wanted the consumer to pay more money, $50 more, I believe, to install it if you wanted it with your door?
I think that was a helpful fact for us.
Did that establish that the garage door manufacturers were basically saying, this makes the door safer, but if you want it safer, you have to pay more money for it?
That was our contention, absolutely.
It just seems kind of odd why they just didn't put it in there to begin with and charge more money for the door.
It surely does. It surely does.
Was there ever any reason given for that?
To lower the cost of the garage door itself. That's
yeah.
You know, the greatest sins in corporate America in our country have been committed in the name of making the product cheaper, to sell more, to make more money at the expense often of the consumer.
Yeah, and oftentimes, if later on the product proves to be unsafe, the manufacturer doesn't want to recall anything because it might cost them a lot of money because they're looking at all the garage doors that have been sold, correct?
Sure, and sad to say, and on balance, there have been instances, and you know of them, in America where there have been calculated decisions to say, well, if we put this on the garage door opener, we put this on the car, or that on the car, it's going to cost us X number of dollars more. We're going to make X number of dollars selling so many units of widgets or whatever.
Yeah.
And at the end of the day, it's cheaper to kill a few people or cripple a few people than
and
fix
defend
the
it in
product.
court.
Yeah.
What was the defense's claims? What was their strategy based on?
The time-worn, time-honored strategy of the defense, to blame it on the mother for taking the nap, to blame it on the little girl for probably playing under the garage door, and to suggest that these things can happen no matter what, and it was really their own fault that this happened.
Now, in some cases, you're helped by people coming forward.
Yes.
Documents being found.
Mm-hmm.
In this particular case, what was really a help in you finding a retired worker that used to work at the manufacturer?
Yes, we did secure an affidavit that was filed in the case from a former employee of the manufacturer, actually just a few days before the mediation in this case, at which it was ultimately concluded, who described in great detail the nature of the problem that had led to Ashley's injury, why it was there, why there was a little bit of slop, if you will, in this kind of garage door that allowed just enough room for it to come down and compress a little girl's neck and not go up. It had to do with the snow, the ability for snow to go under the garage door. And this was all laid out in an affidavit for the manufacturer, who at the time of the mediation was quick to point out to me that the very same case that we had with a little child trapped under a garage door had I think it was in Utah, been filed in federal court against the same company, very same facts, very same circumstances, indeed even similar experts that we had in our case, and that case had been thrown out by the federal judge and that jurisdiction, and the child and the family got nothing.
Mm-hmm. So the manufacturer was aware of this danger?
According to our expert, they were.
Mm-hmm. And that's what kind of cinched the settlement of the case,
in
right?
In my estimation, yes.
Uh-huh. This brings up a big issue when people are injured by products. What should they do when they are injured by a defective product immediately? Let's take any product. Save the product for evidence, right?
One of the threshold things that is needed in a product liability case is exactly as you said, the product. If you're in a car crash where your airbag doesn't deploy, or a roof collapses in a car, or something fails on any instrument, whether it's a garage door, a lawnmower, or whatever, and you're injured by it, the product should be saved.
I think it's also important to tell our audience that, for example, if you buy something that's in a box, save the box.
Yeah.
Because oftentimes there are so-called disclosure statements or instructions that may not be absolutely safe or protective, correct?
Right. Warnings.
So saving all of that too, right?
Warnings are often issues in cases like this, Steve. Many products would be safe if they had a sticker on them telling you not to do this or not to do that. And thanks to the maligned trial lawyers in America, you see many products today that are much, much, much safer, that do have appropriate warnings. I mean, we have seatbelts today probably thanks to we lawyers.
Yeah, because the manufacturers would not have implemented these safety devices. What should you do, what should a person do if they are injured by any product immediately, besides saving all the documentation and that sort of thing?
Well, I mean, obviously they should get medical assistance first, and if they have a suspicion that it was a thing with a product or a car, device, whatever, they should contact somebody about it and see if it's indeed a situation where it ought not to have happened.
Mm-hmm. When you have cases like this is a case that's settled confidentially, right?
Yes.
It's a question that always comes up, you know. When you pursue a case, when you prosecute a case, you have every intention to go to trial.
Absolutely.
You spend a lot of time, a lot of money, all this other sort of thing. When is it the appropriate time to settle the case? Because oftentimes your client may not be aware of what their future medical needs are. Like, for example, Ashley today is how old?
Ashley would be like 16 today, I think.
16 years old?
Yeah.
Okay, she has a lot of expensive future medical needs. The parent may not be aware of what they are, so you hire an expert to determine that, don't you?
Yes.
What is that expert called, and what do they do exactly?
The kind of expert that calculates future medical costs in a situation where somebody's severely injured, like Ashley, is what is known around the country as a life care planner. And they are normally nurses, caseworkers, almost always RNs of some type, who have a special skill in going around to all the medical providers that the person needs or will need and projecting into the future the costs of those things, and then that number, whatever it may be, that cost is analyzed by an actuary or an economist and projected out over the child or adults, as the case may be, life expectancy to say it will require approximately X number of dollars to meet the medical expenses for this child or this adult.
When that's presented in court, oftentimes the other side, the defense, challenges it, right?
Yes.
And says, it's not going to cost that much, right? They can go to the county general hospital, right? They can get substandard care, correct?
Right.
Who decides? Is it the jury that decides finally what is realistic and what should be awarded?
The jury decides, yes. And we always make it a practice of being square and conservative on those figures, so there's not room for that sort of argument.
Is this another case where a lot of lawyers would not have taken the case and you decided to take it?
It was a challenging case because of the history of cases like this, Steve. I'm sure there are many lawyers who would not have touched the case, but we were happy to do it.
Is it very gratifying to see new legislation passed to protect consumers as a result of a case like this?
It certainly was, and thank God the frequency of this kind of tragedy with garage doors has diminished dramatically.
Well, again, we admire the verdict that came in, the settlement that came in, and we thank you very much for being on our program.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.